The United States Supreme Court just dropped a 6-3 emergency ruling. And let me tell you, this one is sending shockwaves through Washington. And honestly, through every state capital in the country right now. Because this decision, it has the potential to fundamentally reshape the balance of power between the federal government and the states. But before we break this whole thing down, do me a quick favor, hit that subscribe button. Because if you care about major Supreme Court decisions that actually impact real-world policy, you don't want to miss what's coming next. The emergency ruling breakdown. Here's what really happened. Late last night, the Supreme Court released a 6-3 emergency decision, and this one directly challenges how federal courts have been operating for the better part of 2 decades. The majority opinion makes something crystal clear. Lower court judges no longer have the authority to issue nationwide injunctions. Those sweeping orders that freeze state laws across all 50 states, even when only a small group of plaintiffs is involved. Now I know, that sounds like legal inside baseball, but stay with me here, because this matters a lot. Over just the last 10 years alone, more than 60 nationwide injunctions were issued by single federal judges. Think about that for a second. One judge, one courtroom, one ruling, effectively overriding laws passed by entire state legislatures. What the Supreme Court just did was slam the brakes on that entire practice, hard. And the timing could not be more critical. Right now, there are 47 active federal cases where states are seeking exactly these kinds of blanket injunctions. But here's the part almost nobody's talking about yet, and trust me, this is where things get controversial. The constitutional argument nobody saw coming. The reasoning behind this decision goes much deeper than most legal analysts expected. The concurring opinions dive straight into constitutional history, and the message is blunt. Historical evidence from 1789 through 1850 shows something fascinating. Federal courts in early America did not issue injunctions beyond the specific parties standing in front of them. Not once. 12 separate founding-era cases were cited, where judges explicitly rejected requests for broader relief. Even when plaintiffs argued that broader rulings would be more efficient, that historical analysis carries serious weight because it suggests that nationwide injunctions may have zero constitutional foundation, not something written into the system, but something modern courts gradually invented. Justice Thomas pushed the argument even further, pointing directly to Article 3 of the Constitution and emphasizing that federal judicial power is limited to cases and controversies, specific disputes between actual parties, not abstract policy battles affecting millions of people who aren't even in the courtroom. Now, the dissenting justices attempted to counter, leaning on civil rights cases from the 1960s. But the majority's response? Those cases may have been wrongly decided on this procedural question. What makes this especially explosive is what it means for the 15 states that already filed briefs relying on the old system. Because overnight, the ground just shifted beneath them. The immediate political earthquake. Within 3 hours of this ruling going public, state attorneys general were already reacting fast. 12 different states issued emergency filings in their ongoing federal cases. Texas cited the decision in 3 separate lawsuits tied to federal immigration policy. Florida referenced it in cases involving election law and social media regulation. Arizona invoked it in a border security dispute that's been stuck in the Ninth Circuit for 8 months. That speed tells you everything you need to know. Legal strategists see this as a massive shift. Behind the scenes, the Department of Justice reportedly held emergency discussions early this morning. Senior attorneys reassessing litigation strategy across 23 ongoing cases. Federal agencies are now being advised to prepare for a very real possibility. State laws previously blocked by injunctions could suddenly become enforceable again, potentially as soon as next week in some jurisdictions. Republican governors are already signaling enforcement plans. Democratic attorneys general are scrambling to evaluate protective options. And this raises a serious question. One worth thinking about. If your rights depend on which state you're standing in when you assert them, are those truly constitutional rights, or are they geographic privileges? Because the answer to that question shapes everything that comes next. The litigation strategy revolution. This ruling completely rewrites the federal courtroom playbook. For the past 20 years, advocacy groups on both sides of the political spectrum used a tactic known as forum shopping, filing lawsuits in districts known for sympathetic judges likely to issue nationwide relief. And the data on this is wild. Between 2017 and 2021, 78% of nationwide injunctions against federal policies came from judges in just 5 districts. 5. Despite those districts representing less than 4% of the U.S. population. One of the most extreme examples? The Northern District of California, where just 3 judges issued 19 nationwide injunctions in 4 years, more than the entire Fifth Circuit during that same period. But now, that strategy is effectively dead. Plaintiffs seeking broad impact may now need to file in multiple jurisdictions simultaneously, which means one thing: litigation costs are about to explode. What used to be a single filing could now require 15 or 20 parallel cases, separate attorneys, separate arguments, separate appeals. Major law firms are already warning clients. Civil rights litigation, environmental challenges, constitutional battles, all potentially becoming 5 to 10 times more expensive. But here's where this gets even more serious, because some cases carry life and death consequences. The life and death policy implications. Let's talk real-world enforcement. Immigration is the obvious flashpoint. Federal agencies currently operate under multiple injunctions affecting deportation policy, detention standards, and asylum procedures. Under the new framework, many of those injunctions could become geographically limited, meaning full enforcement might resume in states not covered by specific court orders. Second Amendment cases are equally affected. Gun regulations in several states are currently frozen by nationwide preliminary injunctions. If those injunctions are narrowed, state officials could begin enforcing restrictions on everyone except the named plaintiffs. Imagine that scenario: your Second Amendment rights changing the moment you cross a state line. Healthcare policy? Another pressure point. Abortion medication, gender-affirming care, religious exemptions, environmental regulations, also deeply entangled. Clean air rules, water protections, climate-related mandates, which leads to another critical question. If federal law can be enforced in Texas, but not California, based purely on litigation geography, are we still operating under one constitution or drifting toward 50 separate legal systems? And nowhere is that tension more volatile than election law. The election law time bomb. Election litigation just became significantly more complicated, and the timing, extremely sensitive. There are currently nationwide injunctions affecting voter ID laws, mail-in ballot procedures, early voting requirements, and voter roll maintenance. Under the Supreme Court's new framework, those injunctions may only protect voters tied to specific jurisdictions, meaning a single state law could be enforceable in most of a state, while blocked elsewhere. Election administrators now face a logistical nightmare: training poll workers, printing ballots, setting rules months in advance. Both political parties relied heavily on nationwide injunctions. Both sides are now losing a major legal weapon. We may see election rules varying not just state by state, but county by county, which raises the inevitable question: will Congress step in, or are we heading into one of the most legally chaotic election cycles in modern history? The business and economic chaos. Corporate America is watching this very closely, because multi-state businesses may now face wildly different regulatory environments. Compliance costs could surge. Banking regulations, cryptocurrency rules, consumer protection standards, technology companies navigating content moderation and data privacy requirements, healthcare providers dealing with coverage mandates and telehealth rules, pharmaceutical companies assessing FDA enforcement risks, employment lawyers already warning clients about shifting workplace standards, and the biggest challenge? Uncertainty. Businesses won't know which injunctions survive under the new rules until lower courts revisit cases individually. The civil rights complication. This is where the philosophical tension becomes unavoidable. Civil rights organizations argue that limiting injunctive relief may force victims of discrimination into repeated legal battles across multiple jurisdictions. Historically, Broad injunctions were crucial in dismantling systemic discrimination. Disability rights advocates expressed similar concerns, especially regarding enforcement mechanisms tied to the Americans with Disabilities Act. And this exposes a fundamental constitutional tension, preventing widespread harm versus judicial limits defined by Article 3. Which principle takes precedence? And who decides? The Supreme Court power play, step back, look at the bigger picture. This ruling is also about the Supreme Court reasserting authority over the federal judiciary itself. By issuing this decision through the emergency docket, rather than waiting for full oral arguments, the court sent an unmistakable signal. Compliance is expected immediately. Statistical patterns show increasing reliance on emergency orders, shadow docket rulings, and summary reversals. Lower courts now face broad directives with limited procedural guidance. Some judges privately express frustration, others see necessary correction. Either way, the practical reality is clear. The Supreme Court is actively reshaping how federal litigation operates from the top down. This ruling changes everything about how federal power interacts with state law, and we are only seeing the beginning of the fallout. If you want to stay informed on major legal developments like this, make sure you're subscribed, hit the like button, and drop a comment below, because I want to hear your take on this decision.